TPS holders and adjustment of status in the light of what's happening, changes in policies, Supreme Court decision, court orders. What can I possibly do? Can I adjust status? We are going to answer those questions. My name is Bijoux Ngwanda. For those who do not know me, I am an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with US immigration laws. And also, we are taking complex immigration cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, again, please go ahead and share, like, and don't forget to comment below. Also, don't forget to join us on our private Facebook group where we answer questions live at least once a week or once every 2 weeks. You have to really be patient with us, and when we join the private Facebook, please don't forget to post your first question so we can help you as well. So let's get into the subject. TPS and adjustment of status. I am going to divide it in 3 categories, okay, of TPS holders with valid TPS status, right? The first category of people who can adjust status are people who have a final order of deportation. Remember, those people previously, they couldn't adjust status because USCIS keep denying their green card application based on the fact that jurisdiction remain with the immigration court. Remember, if someone has a final order of deportation, it simply means that they're still in removal proceedings, right? Jurisdiction is with the immigration court. If someone is in removal proceedings, they cannot go to USCIS. They just have to go to immigration court in order to apply for adjustment of status, unless they terminate the cases with the immigration court, or unless an exception applies, right? Those people couldn't adjust status because they will go to USCIS. US will say, well, jurisdiction is with immigration court. They'll go to immigration court. ICE didn't want to terminate proceedings because they just didn't want to terminate, like reopen those cases and terminate immigration proceedings, so to allow them to go back to USCIS and adjust status. So they were stuck. What happened was they sued USCIS, and when they sue USCIS, they won, and now they can in fact adjust status with USCIS, provided that ICE terminates their case, and ICE is forced to terminate their cases, so that they can adjust status with USCIS. Okay. And those are the people who have an approved petition, mostly family-based, because we're talking about the only thing preventing them was immigration having jurisdiction. That's it. They didn't have any other inadmissibility issues, right? So, and mostly those are the people who adjust under family-based qualifying relatives, because unlawful presence is automatically forgiven, right? Now we have second category of people. Those are the people who first enter without inspection, okay? They enter without inspection the first time around, and later on they get I-130 approved based on family base, and they get TPS approved. They go out of the United States on parole using their travel document or parole document, came back and wanted to adjust status. USCIS said that you cannot adjust status because TPS is not admission, and that was a decision from Supreme Court. Supreme Court said that TPS is not admission. You can't just go out and come back and say, well, now I'm back, I can adjust status. TPS is not admission. The status of TPS, is start when they give you TPS. Whatever happened prior, it doesn't concern them. So they couldn't adjust status. Finally, USCIS has again amended their policies. They said that even if the first entry was without inspection, the fact that you got TPS later on and then use parole to travel, now your second entry is with inspection. now you're eligible to adjust status, provided that you don't have any other inadmissibility issues. And most of the time, those people are people who are adjusting under family base because unlawful presence, again, is forgiven under family-based category, qualifying relatives, of course. Okay? Then we have the third category of people. They don't have entry without inspection. They have good entry. Now they want to adjust status under employment base. Are they going to be able to adjust status? You can only adjust status, first of all, if you enter with inspection, lawfully present, with a lawful non-immigrant status, and then no other inadmissibility issues, right? Because they are adjusting under employment base, their problems are totally different. Why? Because prior for them getting TPS, they were unlawfully present. So that hasn't been forgiven. The only thing that forgives that is qualifying relative. Parent or spouse, get out and do consular processing, okay? So those people, they're kind of stuck because they have, unless you have a parent or a spouse who is lawful permanent resident or lawful or you're a citizen, then you can go with 601A and through consular processing, then adjust status. Because prior to you getting TPS, if you were illegal in terms of unlawful presence, employment is not going to solve that problem, okay? Only people under family-based category can waive unlawful presence inside of the US if they have an I-130 approved and meet other requirements as well. So I think we have answered that question. If you have more questions and you really want to understand whether you can adjust status or not, I really will strongly advise that you consult, okay? You can call 202-751-2180, email Bijoux ngwandaesq@gmail.com. Consultation fees apply as usual. Until next time, bye-bye.